Hello and welcome to Amigos IAS. I am Adnan. In today's segment, we'll be discussing the topic, can accused persons who are in prisons, who are in jail, who are behind the bars, can they vote in the elections or can they contest the elections, and what are the various legal provisions and the case laws related to this topic. So this news is because of this person who is Amrit Pal Singh. He is a pro-Khalistani leader, guys. Last year in Assam, he was arrested and under the National Security Act provisions. And he's of course not convicted yet. He is still in the jail. What happens is he wants to contest the Lok Sabha polls from Punjab's Khadur Sahib seat as an independent candidate. Means being inside the jail. He wants to contest for the MP election, guys. MP seat he wants to win here. Fine. He is the chief of Waris Punjab De outfit. Okay. And he was arrested last year. Now, because this person is now wanting to contest the elections, a question comes here. A person who is jailed, a person who is behind the bars, can they contest the elections? What are the legal provisions behind this, guys? So this issue has been debated for long and even reached the Supreme Court of India, of course. And there have been a lot of politicians who were behind the bars, but still they won the elections. Fine. So two dimensions here, guys. What does the law say on jailed politicians? Firstly, no one is barred from contesting the elections unless they are convicted. So accused persons can contest the elections, guys, even if they are in jail. Make sure you note this point. Okay. And if they are convicted, guys, what happens? Not more than 6 years post the expiry of the jail term. That means if a person is convicted and if they are released from the prison, 6 years if they spend after that, after 6 years of completion of this cooling off period, what we can say, then they can still contest the elections in India. That means accused persons, no bar. If the convicted person is there, after the conviction is over and after completion of 6 years from the date of release from the jail, they can still contest the elections in India. This is the current rule, guys. The right to vote and the right to be elected are statutory rights. That is what the courts have told in several cases. In 1975, Supreme Court in the case of Indira Gandhi versus Raj Narayan held that free and fair elections are a part of basic structure of the constitution. That means what? Free and fair elections are the prerequisite of a successful democracy, guys. That is what we are hearing a lot these days. Free and fair elections. And any laws or policies which violate this free and fair elections principle will be struck down by the court. That means what? We need to make sure that everybody is given the right to equality when it comes to using these principles of elections, right to vote and right to be elected. But one important point here, guys, though they are held as a part of basic structure, but the important point the Supreme Court has told, the right to elect and be elected do not enjoy the same status, because it is up to the parliament, it is up to the state legislatures to take a call on the provisions of elections, guys. Free and fair elections, of course, are basic structure. But when it comes to the right to vote and right to contest the elections, they do not enjoy similar constitutional protections here. So what happens in this case? Kuldeep Nair versus Union of India 2006 case becomes very important for us. What the Supreme Court has told here, guys? It told that the right to vote or right to elect, as it was called, is purely a statutory right, which means voting is not a fundamental right and can be repealed. Very important point. When you do Google search, just don't randomly see the headings of many articles, guys. Even this year also, Supreme Court has rejected a plea which has asked to make right to vote as fundamental right. No, it is not a fundamental right, guys. It is a statutory right. And of course, you may now say, then UPSC in 2017 prelims exam, they have given the option of right to vote is a constitutional right. Again, there are a lot of ambiguities over the legal provisions, guys, whether it is a constitutional right or statutory right. I'll come back to that point very soon. Same was held for right to be elected. So right to vote and right to be elected, both are just statutory rights. They are not fundamental rights, guys. That means Parliament can make any law to modify this right to vote and right to contest elections. And now next aspect here. Bar against contesting elections only after conviction. That means what? In section 8 of the RP Act 51, Representation of People Act 51, okay, in this particular section 8, there are of course 8 grounds on which a person can be disqualified. Of that, important ones are 8 clause 1, 8 clause 2, 8 clause 3 guys. Okay, they have given detailed list of the cases in which a person can be disqualified. So let's see the point here. In 8 clause 1, there are so many offences mentioned, whether it is IPC or the bare acts. Let's say IPC 153A, promoting enmity between people on different grounds. That is an offence. It is mentioned as a ground for disqualification in 8 clause 1 guys. And there are many more acts. Prevention of Corruption Act, okay, Sati Prevention Act is there. There are several such acts mentioned explicitly in 8 clause 1. Narcotics and Psychotropic Substances Act, that is also mentioned in 8 clause 1. If you are convicted of such offences, okay, if it is only for fine, okay, only fine has got, you did not get any jail term, still you can be disqualified. Okay, that is one point. Not only that, because if only fine is given, that means on the date you got this convicted, from that date plus 6 years you have to add. Nobody can contest the elections after that. Okay, before 6 years period guys. So I repeat, lest you shall get confused, I will just clarify again guys. 8 clause 1 offences what I have just read, if anybody is convicted of those offences and only fine term is given for them, only fine is given for them, that means on the date of conviction, from that we have to add 6 years. 6 years we have to add for the person. That person cannot contest for those 6 years guys. If they get imprisonment, of course, from the date of release plus 6 years. What about 8 clause 2? In 8 clause 2, offences regarding profiteering, hoarding of important commodities, or let's say other aspects of adulteration, which we are seeing a lot in news these days. If you do adulteration of products like food products, if for these kind of acts, if you violate them and if you get convicted for not less than 6 months, if you get convicted, then what happens? You are disqualified, and from the date of release plus 6 years you cannot contest elections. Now what is 8 clause 3 then guys? 8 clause 3 talks about what? Whatever is not covered from 8 clause 1 offences, 8 clause 2 offences, the remaining offences are 8 clause 3 guys. So 8 clause 1 like Prevention of Corruption Act, Narcotics, Psychotropic Substances Act, Prevention of Sati Act is there, 153 IPC is there, all this. And here 8 clause 2, any offences regarding the adulteration, profiteering, hoarding, etc. Apart from those offences, whatever is left is there in 8 clause 3 guys. Okay, 8 clause 3 says, if you are convicted of any offence other than those mentioned in 8 clause 1, 8 clause 2, you shall be disqualified, okay, provided you should get at least 2 years of imprisonment. At least 2 years of imprisonment you have to get, sentence you have to get guys. After your release, 6 years, you cannot, till 6 years you cannot contest the elections guys. So don't be under the assumption that for every offence it is 2 years guys. Don't forget 8 clause 1, 8 clause 2 guys. Fine. Here it is not always 2 years. Only conviction also is enough. 6 months is enough in these cases guys. Any other offences, then not less than 2 years, and after your release, from the date of release, 6 years you have to add. You cannot contest the elections. This is for whom guys? Convicted people, not accused people. Accused people can contest the elections in India. Fine. I hope you understand the important difference here. Fine. Now, in 2011, an NGO called Public Interest Foundation filed a petition saying that persons who have criminal charges framed against them or have filed false affidavits and having regarding their criminal history, if they have suppressed their criminal history, then what happens guys? They should also be disqualified. But the Supreme Court 5-judge Constitution bench told, we cannot pass such directions, only the legislature is competent to pass such kind of orders. That means those who are having criminal charges, they should be disqualified or they should not be allowed to contest elections here guys. Fine, disqualification is there. That is not approved by the court. They told, let the parliament make a law. In 2016, BJP spokesperson Ashwini Upadhyay, who always files a lot of PILs guys, he sought a permanent disqualification for convicted persons. Right now, convicted persons after completing their jail term and plus 6 more years, they can still come back and contest the elections. He is asking for what? Life ban on convicts for contesting the polls. As of now, this case is pending with the Supreme Court, guys. Now, what happened 2023 last year, guys? Taking note of delay in criminal cases against MP MLAs. Okay, we have brought special MP MLA courts, guys, to decide the cases of, because almost 43%, and as per ADR, almost half the parliamentarians have criminal records. Then they are accused. Why not let us have a quick trial? And if they are convicted, they will lose their seats. If not, they will continue. That is what is the concern here, guys. But many cases are pending. Okay, Supreme Court has told what? All High Court Chief Justices, please register a suo motu case titled, okay, in the matters of designated courts for MPs and MLAs. Special courts are there, guys. Please pass directions to those courts for fast and effective disposal of these cases. But despite this direction by Supreme Court, according to a report, as of April 2024, guys, there are still 4,472 such MP MLA cases which are pending with the courts. That is why it is also a cause of concern for us. And next one, exceptions to disqualification. Very interesting point here. Section 11 of the RP Act. Section 11 of RP Act, okay, gives power for the Election Commission of India that they can remove or reduce the period of disqualification. Very interesting point, guys. And of course, in rare cases, they will do it. In 2019, in Sikkim, okay, Chief Minister Prem Singh Tamang, he was convicted, guys, and he was having 1 year prison sentence. After this 1 year sentence, because Prevention of Corruption Act, 8 clause 1, guys. So here 2 years is not required. 1 year also is enough. Fine also is enough. So that means from the date of his release plus 6 years you have to add. But what the Election Commission of India has done, guys, they reduced his period of disqualification, not 6 years. 1 year plus 1 month they have told, guys. So period of disqualification is 1 year plus 1 month. The ECI has taken a decision, Election Commission of India, that powers are coming from which section, guys? Section 11 of the RP Act. Very interesting point here. So then what happened, guys? This person from Sikkim Krantikari Morcha leader, he went on to win the by-election for the Poklok Kamrang assembly seat in Sikkim, guys. So example is there here. Another situation is what? What happens if your conviction is stayed? Rahul Gandhi case. That means Rahul Gandhi got criminal defamation case in which he was disqualified as per Article 102 of the Constitution, guys. Then Rahul Gandhi managed to go to Surat Sessions Court, High Court, and then finally Supreme Court. Supreme Court gave a stay on the conviction, not on sentence. Stay on the conviction it has given. So if anybody manages to get stay on conviction, then that means what happens here, guys? The disqualification which came because of such conviction will not be there now. A person who got disqualified, okay, because of getting conviction, but if that conviction itself is stayed, then no disqualification exists. You know, in the past, 8 clause 4 was there, no? If a person got disqualified, within 3 months, they can appeal to any higher courts. And if they file the appeal to the higher courts, they can continue. They will not be disqualified. But then, Lily Thomas versus Union of India case, guys. In this case, what happened? The court struck down 8 clause 4 as unconstitutional, that we know. Fine. That means today we don't have immediate protection for any person. If they get convicted for not less than 2 years, they are immediately disqualified. Even if the appeal also doesn't matter. If they get conviction stayed by the higher courts, they can come back. Rahul Gandhi came back in that way only, guys. So I hope you're understanding all the facets here. So last segment of our lecture. So we have seen all the aspects of they can contest or not the accused persons. What about right to vote then? Here again some interesting points are there. Section 62 of the RP Act, clause 5, subclause 5 or clause 5 of the RP Act, we have to understand, guys. What it says, no person can vote in the elections if they are confined in a prison, whether under a sentence of imprisonment or transportation or otherwise. Okay, if they are in the lawful custody of the police, or if they are already under imprisonment or in transportation, that means they are still in the custody of the police, guys. Those persons cannot vote in the elections. Accused persons also, guys, fine. And exception is given for those who are arrested as per the preventive detention laws. For them, the Election Commission will arrange postal ballots at the place of detention. They can vote, But people who are under custody, transportation, okay, those people cannot vote. But interesting point is, if they come out on bail, okay, or if they're acquitted, then they can vote. That is how it is. Now here one interesting point comes, guys. We need to understand Jan Chaukidari versus Union of India 2013 case. Patna High Court in 2004 has told that as per section 62 of the RP Act, those persons who can have the option to be an elector or voter, they only can contest the elections. I will repeat, those persons who can be elector or who can be voter, only those persons can also can contest the elections, representative. But here the law is saying what? Those who are under custody, they cannot vote. So if somebody cannot vote, somebody is not elector, how can they be a representative? That interpretation the Patna High Court has taken. Same was upheld by the Supreme Court in Jan Chaukidari versus Union of India 2013 case, guys. In this case, Supreme Court has told those who are in lawful police or judicial custody other than preventive detention will not have their right to contest the elections. But how Parliament reacts, guys? Because Parliament can offset Supreme Court verdict by passing a law or an amendment. 4 months later, Parliament has amended the Representation of the People's Act 2013. They have amended this, guys, and they told those who are in jail can contest the elections, and they negated Supreme Court order because sometimes for false cases also some people can be in the jails, guys. Fine. And now interesting point. Government has opposed any effort to bar convicted politicians from contesting election for lifetime. Ashwini Upadhyay himself filed a PL, but the government is not happy with this, guys. And in December 2020, Union government opposed a request to impose lifetime ban on convicted politicians. But again, fresh PILs have been filed. They are right now pending, guys. Government is not ready to have a lifetime ban on the convicts from contesting the polls. And accused people also can contest the elections, but they cannot vote. So this is the interesting case here, guys. Again, there was a appeal which was filed, or a PL which was filed by a person, okay, Anukul Pradhan, okay, in 1997. In 1997, Anukul Pradhan case is important here, guys, because they told those people who are out on bail can vote, but not everybody is having money or the influence to come out on bail. What about the right to equality? What about the other people who are in the jail who are not able to get the bail? Why not voting right for them? Those who came out on bail can vote. So here the Supreme Court has told, sorry, prisoners cannot claim equal fundamental rights as the others, even though they do have fundamental rights. And our objective is to stop criminalization of politics. So you cannot try to give rights to people who are inside the jail to contest the election, to vote in the elections. They can contest, but they cannot vote in the elections. And third thing is, if we make these people who are all in the jails, okay, who are accused, if we have to provide right to vote for them, it means lot of money has to be spent to create the infrastructure inside the jails, guys. So these are the logistical challenges Supreme Court has told when Anukul Pradhan has filed a case in Supreme Court in 1997. And in subsequent years also, in 2020, 2023 also, Supreme Court also has denied to entertain the request that people who are in jails should have the right to vote. So interesting points here, guys. Hopefully it is not confusing. Before I end my lecture, here are some of the examples where people who were accused, who are in jail, who have won the elections after contesting, guys. First example, 1977, George Fernandez contested from Muzaffarpur in Bihar, and he has won 3 lakh votes majority, guys. In 1996, Mukhtar Ansari, who recently died, he won the Mau assembly seat when he was still in the prison, guys. Against him, Kalpanath Rai, guys. He was arrested in Tada case, terrorist and disruptive activities case, guys. In 1996 Lok Sabha polls, he contested, okay, from behind the bars and won in the Ghosi constituency. There are many examples, so I have just given 3 examples where people who were in jail, who were in custody, contested elections and won very easily, guys. So I hope you understood the lecture. If you have any questions, please post in the comments box. I'll be happy to clarify. Keep watching Amigos IAS. Thank you.